The federal government has not yet commenced direct payment of monthly allocations to Nigeria's 774 local government areas. Minister of Finance and Coordinating Minister of the Economy, Wale Edun, explained that the Supreme Court's proceedings had not yet been communicated to the Attorney General of the Federation for proper study and implementation. Recall that on July 11, 2024, a 7-man panel of the Supreme Court granted financial autonomy to the local governments, a decision that was opposed by some state governors. The Apex Court emphasized the division of government power into 3 tiers: federal, state, and local governments. To discuss this further is legal practitioner Tunji Abdulhameed. Tunji, always a pleasure to have you on the news. It's been 2 weeks exactly today since that ruling. Why do you think the Supreme Court's proceedings had not yet been communicated to the AGF? What could be the cause of the delay?
Well, even though I am not part of the Ministry of Justice, I don't know their workings, but I think probably a bureaucratic process in the ministry may be causing the delay. But I think I don't expect that there should be much delay on this because the Supreme Court judgment is clear. It says it should take immediate effect. And I think the certified true copy of the judgment is out. So I just for the Attorney General, in my own opinion, to do a note of it and send it to the appropriate agencies for them to take note and do the needful. So why they are delaying it, why there's a delay is not known to me, and I don't think there should be more delay in respect of this.
The minister used the phrase practical delays when he was explaining why these monies have not been pushed forward. Some people say he is exercising caution for legal reasons. Do you think this cautious approach is justified?
Which legal reason again? Supreme Court has spoken. No other court can retort or reverse that decision. So there's no any legal step they are expecting again or whatever. The judgment is clear. It's been stated. If they have any other anything against it, they can't appeal it. They go to God and appeal it. It's trying to be appealed. It must be enforced. It must be complied with. Except we are not following the law. And I don't think that will be the issue. That it be arrangement regarding our payment. They have to do a new account for this local government. The money has been paid directly to the state before now, based on the joint account provision in the Constitution. But now that we don't have joint account provision, each local government, that's 774 local governments, will now have to provide a detail of the account to be done, and that may have a procedure to be followed, or in terms of registering those accounts there for them to do that. So maybe probably those are the issues, but they did not come out to tell us the main reason why the delay is coming up. But there is no excuse regarding any legal step. There is no any legal proceeding that can stop the enforcement of that order, because it's a Supreme Court judgment and cannot be appealed against.
Thank you for that clarification, though, because, I mean, the conversation has been a little worrying. The decision has already been made. While the AGF awaits the true copy of the Supreme Court ruling, because that is what he has said, I want to ask you what the potential consequences if this payment to the local government and their constituencies is delayed even further. Add to that the concerns about the local governments that have caretaker committee, or some that are virtually non-existent. How will these monies be utilized, and where will they go to? Who will work to make sure that the monies come?
As far as law is concerned, only 774 local governments are recognized. Any other local governments, whether SCDA, whatever name they call it, they are on their own. They will make arrangement within themselves. If they have the same party, good for them. They can have understanding, and they can know how to distribute the money within themselves. But if they have, even if we have the same party, and they have a chairman who is a castrant, they can't force him. It will be difficult for the SCDA to get any money. So it's going to be difficult for them, but it can be arranged between themselves if they have understanding. But where there is no understanding, that's what the problem is. If we have, for example, if you have a ruling party, the governor is from a party A, and some of the local government chairmen are from the other party, they may not agree with the government, the governor. And in that regard, they may not be able to share the money to any other SCDA or local government not satisfied with. And that they can even create a supremacy between them. One local government will say, look, I have issue with this SCDA, so I'm not going to pay them. I don't have anything to do with them. The money is for me. It's not for any SCDA. So it's going to be, in any way, I think most of the states will work it out. Those who have SCDA, they will find a way around it, work it out, or even cancel the SCDAs and they refer back to the normal local government recognized by the Constitution. But
Okay,
as far as our law is concerned, only 774 local governments are entitled to be paid directly.
Okay, I was going to ask you, the first part of my question was the implications if these monies are, or the consequences if these monies don't get to the local government in good time, if there are further delays, basically.
It can only cause a delay in payment of the salaries of or delay in certain projects of the local government. But eventually it will be paid. I think they will be working practically to make sure it's paid on time. Otherwise, the development in local government, progress in local government will be retarded, and then it will not be good. I think they will pay it. They will find a way around it. They know how to do what they are doing, and it should not take time for me as far as I'm concerned, because but I don't expect them to say because of this delay the money has been paid to the states. That would be contempt, and that would be contrary to the position of the law.
I'm sure the AGF will not do that, hopefully. Thank you very much for speaking with us.
Thank you for having me. It's my pleasure to be with you.